Number 116446, State of Kansas v. Charles Glover.
Good morning, Your Honor, Chief Justice, all the justices. My name is Elbridge Griffey, and I'm here on behalf of Mr. Charles Glover. My understanding is that you want a brief synopsis of what brings us before the court.
Yes, because there are people watching on the internet who have not read the briefs and don't know what the case is about.
Your Honor, and everyone involved, this is a case that came out of a traffic stop in Douglas County, Kansas, in April of 2016 that resulted in Mr. Glover being charged with driving without a valid driver's license and habitual violator. On that date, an officer with the Lawrence Sheriff's Department was on a routine patrol, and as part of that patrol, he observed a Chevrolet pickup truck. As part of his regular job, he ran the truck's license plate number through the Kansas Department of Revenue's files. The report came back, and it indicated that the truck was on the vehicle that it should be on, and it also showed that the plate was registered to Mr. Glover and indicated that he was currently revoked on his Kansas driver's license. Although the officer did not observe any traffic infractions or any other basis for a stop, the officer made the stop based solely on the information that he had that the registered owner had a driver's license that was suspended. And as I stated, Mr. Glover was charged based on the fact that he was suspended at that time.
And this was submitted on stipulated facts?
Correct.
And one of the stipulations was that the deputy just assumed that the registered owner of the vehicle would be the driver.
That is correct.
There was no other indicia or reason to believe that Mr. Glover was the actual driver?
Absolutely nothing.
Okay.
Judge, we did file a motion to suppress the evidence based on the fact that we did not think that there was reasonable suspicion to believe that a crime had been committed or was being committed or was going to be committed, and that specifically the evidence showing that the registered owner of a vehicle had a suspended driver's license without additional information should not support a reasonable inference that the driver is in fact the owner of the vehicle. Judge Martin granted that motion to suppress. Well, the state filed a response. We had a suppression hearing. Judge Martin granted the motion to suppress, and as part of her rationale, she brought her own family circumstances into experience, and that she has 3 cars that are registered in her name, that one of those cars is operated in Washington, D.C. every day by her daughter and doesn't have anything to do with her. Additionally, one of the cars is operated by her husband, and she found that this was not a reasonable basis for this stop. The state filed an interlocutory appeal. We had argument before the appellate courts, and the appellate court overruled the suppression at the district court level, and basically their decision was based on the fact that they found it was a reasonable inference that if a car had a tag that came back to a suspended driver, that with absent information to show that that wasn't the person driving the car, that it was a reasonable assumption that it was the registered owner driving the car. I think that that's what they based that decision on. We filed a petition for review, which brings us here today. We have briefed this numerous times. I don't know that I have a lot to add to the information that's contained in the brief. I would just, at this point, state that we believe that in order for a law enforcement officer, well, first of all, stopping a motor vehicle is always a seizure. That's pretty much established law. And in order for a seizure of a citizen to be constitutionally reasonable, according to Kansas statute, the officer must have a specific articulable fact that creates a reasonable suspicion that the seized individual has committed, or is about to commit a crime or a traffic infraction. I think that it's significant that this talks about the seized individual. And in this instance, we don't even know who the individual is that's driving the car. And it would appear from the appellate court's decision that as long as the officer does not become possessed of information to the contrary, they can just automatically make that inference that the person operating the car is the driver, and that would provide reasonable suspicion. And I don't think that that's
Would you call that an inference, or would you call that an assumption? Usually an inference follows from proven facts.
The court used the term inference. It's funny that you mention that, because in my notes I have a one-line note to myself: is this an inference or is it a presumption? I would assume, from my perspective, I would say it's more of a presumption because it's not inferred from anything. Additionally, the standard of a review.
Well, isn't it inferred from the fact that there is an owner of the vehicle? It isn't.
That's what the inference, that's what it's being represented as being based on.
Right. I mean, it may not be enough, but it is based on that. It may not be reasonable to draw that inference.
Well, and then that would take us over from inference into presumption, correct?
And I think, as was already mentioned, the stipulation of fact used the word assumed rather than inferred in terms of the officer assumed. Isn't that correct?
Correct.
Did you draft those?
I did. I'm reading from the syllabus of the court in part, and I don't know, I may have misspoken. I drafted, obviously, my motions.
Who drafted the stipulated facts?
The state,
The state?
and then we definitely
And you
reviewed it.
agreed with them, obviously. You stipulated to them, and
Yes.
those indicate that the officer assumed.
Assume, I would agree with that if that's what's on the paper. And an assumption, an inference. At any rate, they didn't have any other information other than that. There wasn't a crime that was observed, and I would say that there was no particularized suspicion. Particularized suspicion as to this individual is committing a crime almost seems to indicate to me you have to have some idea of who that individual is and not just assume that it's the person that this car is registered to. I would also ask the court, and the theme of this case is that in these types of reviews, an appellate court is called upon to employ common sense and ordinary human experience in evaluating the totality of the circumstances. And throughout these cases, the Hammock case, which the state relied on, and I think quite heavily, and is mentioned in the syllabus from the appellate courts, they talk about what essentially is a totality of the circumstances assessment. And that based on factors of quantity and quality are considered in the totality of the circumstances, that every bit of information must be taken into account to determine whether there is reasonable suspicion.
In these totality of the circumstances cases, should the district court receive any deference when its decision is reviewed? I mean, you won at the district court level here, correct?
Yes, I did, but I want to give you an honest assessment of that question. Obviously, it would be in my benefit to go, yes, they should be given deference. I think that there's an argument to be made that the district court should be given deference because they're the ones that actually heard the testimony and they were involved.
I think we typically say it's de novo review, but there's some case law that suggests deference is appropriate also. I just wondered if you had a position on that, and if you don't, that's fine.
I would say that there should be some difference.
When there's actual
Even-
live testimony and live witnesses.
Correct.
But on a stipulated situation, does it matter as much? Even if we were to grant deference on a live hearing?
I think that would have to be assessed on a case-by-case basis.
And here, under the stipulated facts, are there any other circumstances?
None.
So when we're talking the totality of the circumstances, in this case, we're talking that the officer assumed the person was the driver who was, or the registered owner.
Correct. And if I might backtrack just a moment to just start, and I don't have the memory at this point in my life to go through all the cases that have been briefed on these, because there are many, many cases. But Hammock, the case that the state relied on and is referenced in the syllabus of the appellate courts, there wasn't just information that Mr. Hammock's license was suspended. The car had been stopped. There had been 2 previous citations within the previous 2 months showing that this individual had been driving that car. I would agree that the state has brought some cases up, and there are states that have appeared to issue a black letter law, or, you know, that if the licensed driver, the registered owner of the car is suspended, that gives the basis for reasonable suspicion. I just don't think that jives with Kansas statute or Kansas case law. There are a number of cases that are cited by both the state and by the appellate courts to argue that that is the appropriate decision. However, if you read through the majority of those cases, very few of them stand on a stop based on the driver's license of the registered owner being suspended. Most all of them have some other information. There's been a previous interaction within a recent time that the windows are tinted too darkly to allow an officer to look and see who's driving the car. Well, if you're driving a car that's registered to a suspended owner and the tint's so dark you can't look in there, maybe you've got reasonable suspicion to make that stop. But I think it has to be on a case-by-case basis.
Counsel, in Hammock, just remind me if you can, was that also a situation where the officer was familiar with the driver?
The car had been, I know that the car had been stopped previously.
And there have been citations for
There had been
driving while
citations for
suspended?
driving while suspended within the previous 2 months.
Okay.
So whether that's familiarity with the driver.
I was
that-
talking more about just personal recognition of them. I'm probably maybe thinking of another case. Thank you.
Okay.
On the subject of persuasive authority, the Court of Appeals does list a number of state Supreme Court decisions that seem to support the syllabus that the Court of Appeals crafted. Do you know whether that position is a majority position in the states, a minority position? Do you have other state Supreme Courts that have gone the opposite direction?
I do not have. I think that there are several appellate courts that have indicated a different direction. But as far as if I had found a case like that, it had been in my brief, and it's not there. The issue of totality, the other issue I'm thinking of, that they said that this would be too onerous of a requirement for law enforcement officers if they're in traffic, that they might have to maneuver to where they could see the individual to observe whether they are the same race, gender, age, any number of things that I think need to go into a totality of the circumstances analysis. That to say that it's too difficult for an officer to do some additional investigatory work before he makes a seizure of a citizen seems to be rather inconsistent with other aspects of Fourth Amendment law. You have to have a reasonable articulable suspicion. You can't act on a hunch. or an assumption. The fact that these types of, if this became law, the fact that this would fall harder on, I think, people that are financially less affluent. Clearly, at any given time, I don't have proof of this or statistics, but as important as a person's driver's license is and their ability to get to and from work and conduct their business, if you're possessed of the financial resources, you're going to take every effort to get your license reinstated, including paying the reinstatement fees and all of those things. So I think that people who are financially better off are going to be less likely to have periods of time where their driver's license would be suspended for an extended period of time because of finances. I do think that one of the more persuasive arguments that kind of supports my position on this is that we raised public policy concerns. We raised, the fact that this isn't a reasonable suspicion, that the courts have said this has to be a totality of the circumstances and analysis, and to apply common sense and ordinary human experience to this. On page 9 of the syllabus by the court, when the court's addressing things that might mitigate the negative impacts of a law like this, or this being applied this way, it states in the last sentence, if an officer is aware of any information suggesting that the inference is not valid in a particular case, for example, that the vehicle's driver appeared to be much older, much younger, or a different gender or race than the registered vehicle owner, reasonable suspicion would dissipate. Well, that's in their synopsis that seems to contradict the requirement that the officer have something more. These are, in fact, the exact things that would show that there wasn't a reasonable suspicion in a stop like this. And I think that, although I know that the state would love to have something concrete in line, I just think that the nature of these types of stops are such that they just need to be addressed on a case-by-case basis.
Thank you, counsel.
Thank
Do
you.
we have any questions? Thank you.
I don't know if I asked for 3 minutes before, but if I didn't,
You did not.
okay, well, we're good enough. Thank you.
Thank you.
May it please the court, Andrew Bouch, Assistant District Attorney, Douglas County, Kansas, arguing on behalf of the state. The state is asking you to affirm the Court of Appeals, the decision they rendered in this matter, and that was that an officer has reasonable suspicion to stop a vehicle when the officer believes that that registered owner has a suspended license and the officer doesn't have any additional information identifying that driver.
Counsel, how does the state meet an evidentiary burden with an absence of evidence?
With an absence of evidence,
Yeah, an absence of evidence. You just read the holding, or summary of the holding of the Court of Appeals,
so
and half of that is an absence of evidence.
the absence of evidence that they were discussing here was regarding the identity of the driver.
Right, exactly, which is a pretty critical part of the reasonable suspicion when you pull somebody over.
Yes. Well, and so the situation would be that obviously if the officer is next to the driver and they can look at the driver of the vehicle, that would be some evidence that would then need to be considered.
We didn't have that here.
We did not have that here. That is correct.
So I'm talking about this case and what there was, and all there was knowledge that the registered owner of the vehicle had a suspended license. That's it. That's
Well,
the whole case.
yes.
That's your entire evidentiary load to meet your burden to demonstrate that this was a constitutional stop.
The question is, did that deputy mayor have reasonable suspicion, which is specific and articulable facts, along with a rational inference? His specific and articulable facts in this case were that he was following the vehicle, he ran the license plate through the in-car computer, which indicated, through the Kansas Department of Revenues, which indicated that plate returned to that vehicle. The records indicated that the registered owner of that vehicle had a suspended license.
Right,
So
that's
those-
a multi-step description of what I just said.
Yes, those are the specific and articulable facts. Then the next question is the rational inference. So was it rational for Mayor to believe the owner is also the operator in front of me?
But you have to make, that isn't all the facts you know, or those aren't all the facts this officer knew. He knew that, and I think Mr. Glover's license was actually revoked.
Yes.
And he had a revoke. So you're saying it's reasonable to believe not only that the owner is the driver, but an owner with a revoked license who's not legally able to drive that car was breaking the law and driving the car. Why isn't it a reasonable inference that when this Mr. Glover was revoked, he had someone else driving his car for him? You understand what I'm saying?
I understand what you're saying.
You're saying that we just assume the registered owner is breaking the law.
Well, what I'm saying is that is a rational inference that other courts, other jurisdictions have found. For instance, in Vance in Iowa, they said this is not, this isn't infallible.
But
They
haven't-
said you may have these instances where, like the district court here, she said, hey, I've got 3 cars and I have 3 different drivers in those cars. That was her concern, and I understand that concern. However,
And I suspect if her driver's license was revoked, we can reasonably assume that she would not have been driving any of those 3.
I
Or
don't
would
think
make
that is.
assumption.
I think to say that just because somebody has a suspended driver's license that they're not going to drive a vehicle is not accurate.
Well, didn't the Supreme Court tell us the opposite of that in Terry? Didn't they say we can't assume, I mean, cannot assume criminal conduct is taking place and detain someone without, quote, specific and articulable facts which, taken together with rational inferences from those facts, reasonably warrant that intrusion.
Well, we need to get away from, you can't just go on a hunch, just like I see somebody and I'm going to go.
Isn't that all we have here, though?
No, I
Is
don't.
a hunch that the owner is the person that is in that car. We don't have any more than that.
Well, you got to look back to what the officer's actually relying on, though. He's relying on Kansas Department of Revenue records, the keeper of the records with the vehicles, with the driver's licenses. So they're relying on a state agency that is the keeper of all these records.
But again,
it's
you're
still-
assuming that somebody's going to commit, to break the law.
Yeah.
And,
Well,
and
essentially,
you can't
yes.
do that without articulable reasons of suggesting why they would break the law. Just because a car's moving down the road, is that enough? When there are reasonable options of, I mean, in today's age, a person who hasn't a revoked license but owns a car could very easily be using one of the services where you rent to other people to at least make some income off your car while it's sitting idle. I mean, there are lots of options of why others would be driving this car.
That is,
So what is the articulable suspicion that lets us know this person should be seized?
well, based on the totality of what you're dealing with here, I think that those are articulable facts that the officer is relying upon. You know, they talked about this in Vance.
But Vance also does the opposite of what we say in Kansas, that you cannot make an inference based on a lack of evidence. Vance fills that gap of what we know by making this assumption. And in Kansas, we have said repeatedly that that can't happen, that shifts the burden to the defendant.
Well, so, I mean, Vance recognizes that this decision, if you go this route, is it reasonable to assume the officer to make that assumption? They recognize it may be fallible, but it's sufficiently reasonable to generate reasonable suspicion, which is a very low burden. And that's what I think we need to keep in mind, is that reasonable suspicion is a very low burden. So that stop, if it occurs and the officer walks up to the vehicle and they are then able to see, like, if the registered owner is a male and there's a female driving, okay, thank you, sorry for the delay, you can go about your day.
But
Because-
you're not relying on what happened when they walked up here. I mean, and we're not talking about that time period anyway. We're talking about pulling the car over.
Making the seizure.
Yes.
I mean, you're adding facts now.
Well,
to what you've got in front of us. I mean,
Okay.
did you draft this, or did the state draft the stipulation? Was that an accurate answer to that question?
Mr. Griffey, I can't remember if I prepared them and then handed them to Mr. Griffey. We worked on them together.
Okay.
We
Do
believe.
they, is it correct that the way the stipulation reads is that it is an assumption by the officer?
I'm sorry, I don't know. I can't remember exactly if it said assumption or inference.
Well, there's a difference.
Well, I didn't look at Webster's when I drafted that. I'll frankly admit that. To our belief, though, is that when you look at it, he's making an assumption. It's a rational inference.
You think an assumption and an inference are the same thing?
Well, from his point of view, we might have
Do
used.
they have the same legal effect?
I couldn't tell you standing here exactly what the legal definitions of either or, but
How do we, let's skip past this, whether it's semantics or not semantics of the word choice. Assume it's an inference. How would we know if it was reasonable without having some further evidentiary foundation about, for example, statistically speaking, how often are vehicles on the road being driven by the vehicle's registered owner, or even just some more vague testimony about, in my experience as an officer of 20 years, my experience is that almost always, or something to that effect. I mean, we just don't have any of that here. And it's like Judge Martin sort of, she had to fill in those blanks with her common experience. But I'm not sure that's what, is that a failure of proof by the state?
I don't think it is.
How do we tell if it's a reasonable inference?
What specific and articulable facts do you have in this case?
Well, you've recited those. Those aren't in dispute. I'm asking about the reasonableness of the inference. And what do we, as arbiters of the reasonableness, have to draw on here, other than maybe our just common sense and our own personal experience? Is there anything else?
Well, there's that, and there's what I think the 15 other states that we have cited to that have found the position that the state is arguing for in this case. I think that
I'm asking something different. I'm looking for something solid to stand on to say this is a reasonable inference. And I just don't know where to go, other than like Judge Martin did, to my own experience.
well,
I don't know how often cars on the road are being driven by their owners. I could guess.
and I think it's reasonable to believe that if you see a car driving down the road, that it's likely being operated by the owner.
That's
Well,
a guess. A guess is a hunch.
That was, in the old days, when we had non-agency bailment, that was absolutely wrong, because you always title it that someone else, and so you would be a non-agency bailee of that vehicle on a accident with contributory negligence. So there were reasons, and with regard to children and other scenarios, there are reasons that you title it different than the regular user. Maybe not as often as the other way, but we don't know that. You want us to just assume that. And I think what my colleague's saying is you need to prove it, not just ask us to take that on faith. Because if I was going to assume, I would prefer to assume someone was going to follow the law than to assume someone is breaking the law. And what we're talking about here is not the car committing an offense. It's the person sitting behind the wheel. And so you're asking us to assume that that's the owner, it's reasonable to infer the registered owner is breaking the law and is the person sitting behind the wheel.
Yes, that is what the state is asking you to do, and you can decide against that, and you can go with what basically the protocol that New Jersey follows, where they require additional evidence. So they require the officer to investigate further, try and identify who the driver is, male, female, what's their race. So there's the New Jersey case, which cuts against the state, and then there are the 15 cases that we have cited, which we believe supports our position that it's acceptable for that rational inference to be made.
The cases that you've cited, in your view, are the majority opinion of the states that have addressed the issue?
Yes.
Okay, thanks.
Does it have to be a bright line rule? I mean, for example, the reasonableness of this inference might change depending on whether or not the stop happened in New York City or in Gove County, Kansas.
Would you be getting at
Isn't it fact specific?
Well,
You're looking for both parties are looking for a bright line rule in this case, and I'm just not clear how we get there.
okay. Is your when you just talk about New York City versus Gove County, I would make the assumption or the inference, because I've been to Gove County and to New York City, that traffic patterns are different.
Traffic patterns might be different. The
Right.
patterns of drivers. I mean, people who are the percentage of drivers who are driving cars that they aren't the registered owner of might be different. I don't know that, but it would seem reasonable to me to think that that's just not a uniform thing across our wide, diverse, even state.
And that is one of the things that those additional states that we have cited to, going back to Vance, that was one of the second factor they looked at, was by requiring additional investigation, you would ignore factors like heavy traffic, are you driving at night or during the day, or are there heavily tinted windows? So from our position, that's why it's difficult if you add these additional investigatory steps that the state must take, like New Jersey. Then we run into these issues of, okay, what's the traffic pattern like? What's the vehicle, tinted windows or not? Now, that doesn't negate the fact that, let's say the officer is sitting at a stoplight next to the driver, and they look over and they see that it's a 20-year-old female. They drop in behind the vehicle, run the plate, shows that the registered owner has a suspended license, but the registered owner is a 50-year-old female. Well, then that would not be reasonable for that officer to, and there's no other traffic violations that occur. It would not be reasonable for that officer to pull over that car, because at this point in time, they have additional information.
And they would use that information to pull them over for suspected car theft.
I would not, unless it was reported stolen, sir. So that would, I don't think we're going to be in a situation where it's always just officers running plates, pulling people over on that. There's going to be instances where they observe a car pass by, they're going to make these observations, and they will take this in the totality of the circumstances.
Those are not what we have here, correct?
That is correct, sir.
For all we know, the driver of the vehicle could have been driving a stolen vehicle, right?
Well, it's not in the stipulated facts.
No, I understand, but
If it
based
wasn't-
on the few facts that the officer knew, for all he knew, the vehicle was being driven by somebody who had stolen the vehicle. It was not the driver who had the owner who had a revoked license.
I would say no to that, sir, because I don't think that would have been a rational inference based on the facts he had available to him.
No, I'm not saying that
He didn't have any
that
facts.
he suspected it. That's the problem.
There's,
It could have turned out that the person that he stopped had stolen the vehicle.
it could be that turned out that way, but that's not the information he had available to him.
I understand. He didn't know who was driving it.
Correct. He couldn't know until he actually walked up to the car after this and initiated the stop. That's correct.
And we have cases where officers who deal with drugs often will say, in my experience, when you see rolled up bills that suggest drug activity, when I see something else that suggests drug activity, baggies with corners torn out, there's nothing like that here that would have been available for the officer to testify to
Simply
say, in my experience, that when somebody shows up to be, a vehicle's moving down the road, and I run the plate and I learn that the owner has a revoked license, 10% of the time, or 25 out of 30 times in my experience, that person turns out to be the driver. There's nothing like that here, correct?
That's correct. That was not one of the stipulated facts, Your Honor.
Any further presentation?
No, thank you for your time.
Any more questions? Thank you, counsel.
Thank you.
That concludes the presentation of the case. We thank both counsel for your arguments this morning. Court will take this matter under advisement.